Welcome to meeting number 6 of the House of Commons Standing Committee on Finance. Pursuant to the motion adopted by the committee on Thursday, November 19th, 2020, the committee is meeting on government spending. We and the Canada Student Grant Study. Today's meeting is taking place in a hybrid format pursuant to the House Order of September 23rd, 2020. And the proceedings will be made available by the House of Commons website. So you are aware the website will always show the person speaking rather than the entirety of the committee. To ensure an orderly meeting, I would normally outline a number of rules, but I think with the committee we have here today, they know the rules, and I'm sure the Clerk of the Privy Council knows the rules. So we will start with our first witness, and I'd like to welcome from the Privy Council office, Ian Shugard, the Clerk of the Privy Council and Secretary to Cabinet. I'm not sure, Mr. Shugard, if you have an opening statement. If you do, we'll allow you to make that, and then we'll go to questions. And first up on the question list, just for the committee's information, is Mr. Poilievre, Ms. Zerowitz, Mr. Fortin, and Mr. Juliet. Mr. Shugard, the floor is yours.
Thank you very much, Chair. I am glad to be here again. The last time we went straight into questions, but given the subject matter, I do have a statement to begin, which I hope will be helpful, and it has been provided to the committee in the 2 official languages. I was asked to discuss generally the Cabinet confidence exclusions to public disclosure. And I intend to lay out the fundamental principles underlying Cabinet confidentiality. As you know, democracies similar to ours have long recognized the need to safeguard the confidentiality of what is said at Cabinet and what comes before Cabinet, and the documents prepared for those discussions. The reasons are clear. The process of governance in a Cabinet-style democracy works best when Cabinet members charged with government policy and decision-making are free to express themselves around the Cabinet table unreservedly, free to discuss all aspects of the problems that come before them, and to express all manner of views. Confidentiality ensures candor in Cabinet discussions and full and frank exchange. Deliberations among ministers of the Crown and the documents that reflect the content of those deliberations are protected by the Constitutional Convention of Cabinet Confidentiality. It performs a vital role in our Cabinet-style democratic system of responsible government. In a system of responsible government, Cabinet is openly and collectively accountable to Parliament for the decisions it makes during the time it governs. If ministers are to make decisions collectively, the privacy of their opinions and views in developing government policy must be protected. Otherwise, the collective responsibility of ministers to Parliament, which is essential to Cabinet government, would be difficult to maintain. Along with other constitutional conventions, Cabinet confidentiality also serves to uphold the constitutional principle of the separation of powers between the 3 branches of the state. In doing so, it protects the integrity of our constitutional structure. Canadian constitutional law has long acknowledged that sovereign power in this country is divided not only between Parliament and the provincial legislatures, but also among the executive, legislative, and judicial branches of the state. Although there are limited areas of overlap, each branch plays a fundamentally distinct role. In a recent unanimous decision, the Supreme Court of Canada reasserted that each branch must be able to perform its constitutionally assigned functions without undue interference by the others. Several doctrines work to prevent undue interference by one branch onto another. This includes the secrecy afforded to judicial deliberations and the recognition of the privileges, powers, and immunities employed by the Senate, the House of Commons, and the legislative assemblies. In August, the Supreme Court reaffirmed that the executive, too, benefits from a degree of protection against undue interference. The court specified that the deliberations among ministers of the Crown and the records supporting and reflecting those deliberations are protected by the Constitutional Convention of Cabinet Solidarity and Confidentiality. Of course, the Constitutional Convention protecting the confidentiality of cabinet deliberations does not exist just for the cabinet of the day. It exists for all cabinets, for those that came before it, and for those cabinets that will come after it. The Constitutional Convention and the protection it affords is for the benefit of our system of democratic governance, both the concept of cabinet solidarity in responsible government and the ability of the executive branch to do its job. Recognizing this importance, Parliament resolved that access to cabinet confidences is extraordinary. Parliament chose to exclude cabinet confidences from a right of access under the Access to Information Act and the Privacy Act. It did not grant to its agents of Parliament a statutory right of access to cabinet confidences, nor, as a matter of federal law, did Parliament allow our courts access to cabinet confidences. The committee's July 7th motion stipulated that cabinet confidences were to be excluded from the production of documents. This is in keeping with the House of Commons' long-standing practice of respecting the confidentiality of cabinet decision-making. The former Speaker of the House of Commons, the Honourable Roland Michener, in 1957, November, said that the decision of the government is one and indivisible. Inquiry into how it is arrived at, and particularly inquiry into the cabinet process, is not permitted in the House. It is also how the Supreme Court understands the practice of the House of Commons, as noted in the fundamental decision of Babcock. The Prime Minister and members of Cabinet appeared before committees of the House to provide answers to questions about its decisions on the Canada Student Service Grant. The Prime Minister and Cabinet chose to make public its confidences on the CSSG because of the questions raised about the delivery of the program. This is a recognized exception in law to maintaining cabinet confidentiality. As the Clerk of the Privy Council and custodian of cabinet confidences, I directed that a principled approach was taken to the treatment of cabinet confidences in this case to ensure a non-selective application of the protection of cabinet confidentiality. As a result, and in keeping with the public disclosures made by members of Cabinet, considerable information on the grant that would otherwise have constituted cabinet confidences was provided to the committee. This was one case, Mr. Chair, in the context which I have attempted to lay out of the doctrine of cabinet confidences, and I hope that that is useful to the members of the committee. Thank you very much.
Thank you very much, Mr. Shugart. And we will go to a 6-minute round for the first 4 questioners. Mr. Poilievre, the floor is yours.
Thank you very much, Mr. Shugart, for your appearance and for your service to Canada. Question 1 is, can the Prime Minister of Canada fire you?
Indeed, he can.
Right. So you do report to him and you do serve him. How many pages of disclosures in the weed controversy have you determined to withhold or redact under the pretext of cabinet confidence?
Our estimate, and I may not have all of the facts at my fingertip, Mr. Chair, because I understood that the purpose of this afternoon session was the discussion of cabinet confidences, generally speaking, but our internal rough estimate is that less than 2.5% of all of the information provided to the committee was redacted on the basis of relevance, and that about 1% was redacted because of cabinet confidentiality.
That is not consistent with the numbers that we have, which show that roughly half of the total redactions were justified under section 69(1) and the other sections of 69, which relate to cabinet confidence. So do you have an exact number of documents that were either withheld or redacted partially or entirely under the pretext of cabinet confidence? Just looking for a number here.
No, I don't have a number today. I assume that that will be clear in the law clerk's examination of the documents that we're providing.
Well, he can't possibly look at those documents because they remain redacted or withheld. So we were told that you would be the one to come before us and provide us that information.
Well, as I said, Chair, I had made that offer. This is the information that my officials have provided me based on our analysis, but I'm here to discuss cabinet confidence generally and keep.
And that's that's what I'm asking about. And so far, you have not told us the number of redactions or withholdings that you did under that section of the Act. Can you confirm that every single document that you redacted or withheld under the pretext of cabinet secrets actually appeared at a cabinet meeting?
I presume that they would, because they would be documents, either records of decisions or documents that would have been available in the cabinet process.
So physically in the cabinet room when the cabinet met, all of those documents were there?
I presume so, Chair, but I won't make a categorical statement to that effect, no.
Well, you presume so. We've been told by Liberal members that you're the one that decided to withhold or redact them. So it wouldn't be a presumption. You would know if, in fact, it is actually true that you made the decision to withhold or redact these documents.
It's a separate question. The question was whether I could affirm that all of the documents were present physically in the cabinet room.
Okay.
That, I suspect, is a very precise question with a very precise meaning, and I will not declare it emphatically.
So we don't know if they were actually at a cabinet meeting. They are cabinet secrets, but we don't know if they were actually in the cabinet meeting. How many of them were memoranda to cabinet?
I'm not in a position, Chair, today to describe that for the reason I've mentioned.
How many were discussion papers for the purposes of the cabinet decision making?
Well, the same answer applies, Chair.
How many were actual agendas of cabinet meetings or records of deliberations?
The same answer, Chair. I'm not going to quantify that. They would all have been of those types, categories of document.
How many were records used for reflecting communications and discussions between ministers?
That would be the same answer, Chair.
How many were for the purpose of briefing ministers?
Same answer.
How many were draft legislation?
Same answer, Chair.
Okay. How many were records that contain information about the contents of any record related to cabinet?
As to quantification, right. It's the same answer.
Well, so we're not getting any answers, actually, with respect, and I do have a great deal of respect for you, Mr. Clerk, but we're told that you're the one that made the decision to withhold or redact all of this information. I've just listed all of the legal justifications for withholding or redacting cabinet secrets that exist in the Access to Information Act. to find out which of them you actually used for these with redactions, and you can't give me any number to prove that these redactions were actually related to the legal authorities in the Act. So how can we be sure that that one, you were the one that even made this decision, and two, that there was any legal foundation purported or otherwise?
Chair, I indicated in my statement that I directed the public service. Specific redactions were made by departments under the authority of their deputy ministers, but I gave the direction as to the approach that would be followed, consistent with statements that had been made by ministers, and my commitment
to this
committee. My commitment
your decision.
Mr. Polyev, just to give the clerk time to finish his answer, and we'll go on to Ms. Zerowitz. Mr. Clerk, are you completed on your answer?
Well, I'll just finish the sentence, Chair, that I committed to this committee that I would provide the committee with as much information, as transparent as possible, and an expansive definition of access to these documents. And I have answered the committee that less than 1% of the information provided to the committee was redacted by cabinet confidentiality. So I've given a percentage, not a number of pages.
Thank you very much, Mr. Clerk. Ms. Zerowitz, 6 minutes.
Thank you so much, Mr. Chair. And I want to say huge thanks to you, Mr. Shugart, for coming before our committee again. Thank you for your tremendous leadership. Sometimes when we're in the bubble and we go through these committee meetings, we forget that we're going through an unprecedented pandemic. So I want to say huge thanks to you, to your team, to the entire public service for the tremendous work that they're doing through this pandemic, and they continue to do as we move through it. So thank you for coming back. You've actually disappeared. Should I be worried about that?
No, I meant Negan.
Okay.
Mr. Shugart, I think that was Mr. Polyev
okay, sorry
that
about
disappeared.
That. I'm still here.
Okay, sorry, Mr. Shugart. So what I want to make clear, just because it seems like my colleague, Mr. Polyev, is holding out that redactions that are made by the public servants by various departments were conducted in a non-compliant manner. So can you just be clear with us, because you said you provided direction to the deputy ministers of the various department, who actually makes the decision about which cabinet confidences? So who actually makes that decision around the cabinet confidences that need to be redacted or that need to be excluded from what is submitted? And also, can you speak to how the public servants do their job in a nonpartisan professional way and follow their obligations under the Privacy Act?
Yes, on the matter of the redactions, I gave general direction to departments and supported by staff in the Privy Council office, well trained in this area. There were two principal aspects. Documents that normally would be cabinet documents that covered material upon which the Prime Minister or members of Cabinet had already publicly commented. Anything answering that description was to be released, even though it was in the form of a Cabinet confidence. The second thing is that as I committed to the Finance Committee in July, I would, because the question was at the heart of discussions in Cabinet, I would be as transparent as we possibly could be with relevant information, even if it was contained in Cabinet confidences. And so that direction was given to departments, to deputy ministers, and to the people in the departments who do the actual work. They reviewed their documents and they made the redactions. Now, sometimes there's a question that an official in a department will have, uncertainty about whether or not to redact, and that will be referred for advice to their counterparts in the Privy Council office, and that's what occurred in this case. So that what is provided then is in this case, a very large number of cabinet documents, either because they were in the public interest going directly to the matter before the committee and the public controversy at the time, or because the Prime Minister and ministers had already commented on those matters, and in a sense, cabinet confidence was already waived. Now, we do this, to answer your second question, with an absolute conviction about applying the law and the principles in the law. And whether it is convenient for a minister on the basis of any partisan consideration does not enter into it. And I have to say that in my experience, whether working for conservative or liberal ministers, whether answering questions from New Democrat or Bloc or government members, we are trained to do our work without regard to partisan interest. We work very closely with politicians, the elected branch of government, but our conviction in Canada, our values in our public service are to do it without regard for the partisan interest of the day, of the government of the day. And that I can affirm to the committee was how we went about our business in this case, and I would say in every case.
Thank you so much, Mr. Shugart. And I'd say to you, so you were very clear that there's proper training about what to actually redact. So I heard that very clearly. I also heard very clearly that it was done in a complete nonpartisan way. And then maybe the last thing I just want to make sure it's clear, there wasn't a different process when the Conservatives were in power versus than what's happening right now. Because there seemed to be some question as to whether or not there was a different process. So if there were documents that were actually be asked to be submitted to committee under the Conservatives and to exclude cabinet confidences, and they had to be redacted in a particular way, it was done following the same rules under the previous Conservative government as what it is that we've asked for under our Liberal government this time around. Can you confirm that? I can't hear you.
I think you're muted.
Yes, my apology. Yes. No two cases, of course, are exactly the same. But the principles are the same. And one of the situations in previous House of Commons under Conservative government, I should be clear, the House of Commons was not under a Conservative government. There was a Conservative government at that time. The Afghan detainees issue has been very important in affirming and establishing the details of cabinet confidentiality. And although each case is different, the principles are the same, and the process that public servants will follow in applying the rules to the redactions would be the same.
Okay, thank you both. We'll go to Mr. Fortin. 6 minutes, please. Floor is yours. You're muted. Your mute is on, Riel.
Okay, désolé. Merci.
I'm sorry. Thank you. So I was saying thank you, Mr. Chairman, and thank you, Mr. Shugart, for being with us today. I'd like to know, first of all, and I understand that this is a colossal job to black out things in a 5,000-page document, but I'd like to know how you proceeded to come to the decisions. I understand the principles of what it should be confidential, cabinet documents. I don't want to discuss that again. I think we all understand. But how, technically speaking, do you proceed in order to decide what should be blacked out or not? First of all, who are the people involved in this process? Because you're certainly not alone to read those 5,000 pages with a black marker erasing one thing after another. So who participates in this work, first of all? Officials of various levels. there is a supervisory aspect to this, for example, and it's not officials who would be very, very junior, but with sufficient experience. The officials take documents, they read them fully, and it is quite a task, as you mentioned. And we take that marker, and if there's a line, maybe there's a few words, or it could be a paragraph, it could be a full page, even several pages, that meet the description of cabinet confidentialities. They are blacked out. But in this case, and in every situation, we apply the principle. Is it legitimate to eliminate these words or paragraphs or not? Okay, now we're getting a little far away from my question, but that's a good clarification. However, I understand that there are some officials, not very junior people. So I imagine you're talking about senior officials talking about that. But how many people are we talking about, Mr. Shugart? How many people were involved in this process? Oh, well, that depends on the situation once again, but it could be a team. And I'm just guessing here. I want to emphasize that. But for example, we could share the documents among a dozen or perhaps even 25 people, a team to do this revision. For example, the documents that the House requested when the Health Committee started a study currently represented millions of pages. I don't have the exact estimate, but it was a great deal, and it took many officials to do that work. Well, I don't want to be impolite, Mr. Shugart, but you understand we have little time for the questions, so I don't want to push you, but you're saying that between 12 to 25 people were involved in the process here? Is that, did I understand you correctly? You said maybe 12, maybe 20, up to 25? Well, that's more theoretical than that. But I can offer the committee several examples. Well, thank you. So what I understand is that you can't tell us exactly how many people participated in this redaction process, but you were the ultimate supervisor of the work. Is that correct? In theory, yes. Or in principle? Well, why? Well, because I gave the direction at the outset, and if there were any questions or doubts, or any difficulties of interpretation regarding my instructions, the team could ask my team at PCO to make the decision, and so in that sense I am. But ultimately, yes, I am responsible. Could you provide us with the document to tell us who was involved in the redaction process from the various departments and within your own service at the Privy Council? Who are these people? And I'm trying to imagine what the sort of flow chart is to understand the level of these people. And I understand your difficulty to answer our questions as to what passage should remain and what should be blacked out. But I'm just trying to understand how you proceeded with this, Mr. Shugart. Now, you agree that you would provide this information? Thank you. Second, who are the members of cabinet who were consulted in this process? I did not consult the ministers, for I didn't seek any approval on our decisions. I informed the Prime Minister, I believe, if memory serves me well, of my approach to this exercise, but I did not consult ministers nor the Prime Minister in taking specific decisions.
Over to you, Mr. Julian. First round of 6 minutes. Floor is yours.
Thank you, Mr. Chair. Thank you, Mr. Shugart, for your contributions to Canada and your service to Canada. And we hope you and your family and loved ones are safe and healthy during this pandemic. You were asked a previous question, and you said about 1% of the documents were redacted according to cabinet confidences. So can you just confirm that that's about 50 pages of the 5,000 pages that were redacted on that basis or withheld on that basis?
Chair, it hadn't occurred to me to do the arithmetic in answer to the previous questions, but if that were the total number, then it would be in that order of pages. But I don't know if it would be full pages. As I said, a redaction can be a line, it can be a paragraph, but as I said, it's about 1%, our estimate, of the information provided to the committee was redacted on the basis of cabinet confidence.
Okay, I find that disturbing because, as you know, well over 1,000 pages were substantially or completely redacted, so about 1,500 pages of the whole. So if
Peter,
we're talking about...
Mr. Julian, to interrupt, not take time away from you, can you move your mic away a little from your mouth? The translators are having it's coming through a little noisy. Try that.
Thanks, Mr. Chair. Is that better?
Much better.
I apologize. I didn't want to shout in anybody's ear. Since we have about 1,500 pages substantially or completely redacted, it's disturbing, quite frankly, to me that you don't have the ability to answer more fulsomely the questions that we are asking you, because that, of course, was the objective in bringing you here, not the theoretical approach, but rather having a sense of why things were redacted so substantially. Now, I have two questions flowing from that. First off, when you testified on July 21st to us, you stated that there were two cabinet discussions about the We Charity. Can you confirm that those two discussions, of course, were subject to the cabinet confidences? Secondly, what is a disturbing number of pages that are marked not relevant, including references directly to the Canada Student Service Grant. Can you confirm with us how many pages were redacted before they were sent to the law clerk that were marked as not relevant when to an untrained observer's eyes, they are very relevant?
Chair, I want to assure the committee that I don't want to be argumentative, but I also don't want to leave the impression that I have not responded to the committee's request. I wrote a letter to the committee indicating my and my colleagues' willingness to come and explain redactions. That request was changed by the committee to an invitation for me to come and discuss cabinet confidences in public disclosure. So my understanding is that I have today followed exactly the request of the committee. We can follow up with further information and are happy to do so. On the issue of what is redacted, we're talking about those redactions that were specifically cabinet confidences. There may very well have been other reasons for redactions, including, as the member points out, Chair, relevance, commercial confidence in some cases, not, I suspect in this one, solicitor-client privilege, which is a frequent basis of redactions. So no one should think that all of the redactions were because of asserting cabinet confidence. In fact, far from it. The majority of redactions were for other reasons. And we can provide, perhaps in writing to the committee, further elaboration of what those redactions were based on.
Mr. Julian.
Well, yes, thank you, Mr. Chair, and thank you for your answer. But it's very clear what the motion stated, and it actually I was the one who moved the motion. So there was matters of cabinet confidence and national security being excluded from the request. That has been a justification for some of the redactions, but the redactions heavily went far, far beyond that. As you've pointed out, there's a whole number of other categories that didn't reference what the committee clearly indicated. So I have two questions. First, do you understand when the committee asks specifically for documents, it's not the prerogative of the government to decide unilaterally a different approach. That's why we're currently still discussing, though it's suspended, a privilege motion. Secondly, why wouldn't the Privy Council and public servants follow strictly what the committee actually requested back in July?
Well, Chair, this question, the first question in particular, goes right to the heart of what we are talking about. I consider it a natural and a perfectly justifiable thing for a committee of the House of Commons to ask for information, including cabinet confidences, in this case or any other. But equally, as I set out at the outset, the executive branch has the constitutionally affirmed privilege of withholding certain information in order to be able to do its job. In the case of the We Charity question, the government provided considerable cabinet confidence. The Prime Minister and ministers spoke to the issues, even though they contain cabinet confidence. And pursuant to that, the documents themselves were provided in considerable volume. But that does not change the constitutional convention that for reasons of supporting responsible government and the prerogatives of the executive branch of government to do its job, the executive does have the prerogative to withhold cabinet confidences even when the legislature asks for it. And this is a point of tension between the two branches of government. And it is not always convenient, but it is a part of our constitutional structure. And indeed, it has been affirmed by the courts as recently as this summer by the Supreme Court of Canada.
We'll have to end that round there, Mr. Julian. We're a minute and a half over. My apologies, committee, but I do want to clear this up in fairness to the Clerk of the Privy Council. The motion that we passed at the meeting the other day that brought the Clerk of the Privy Council here today said this, and that the Clerk of the Privy Council and the Conflict of Interest and Ethics Commissioner appear no later than November 25th, 2020, to discuss cabinet confidence exclusions to public disclosures, and then it goes on to talk about the law clerk. So I just want to clear that up because there seems to be some confusion about the original motion and the reason we asked the clerk here today, according to the motion. Mr. Polyev, you are on for a 5-minute round. The floor is yours.
Thank you, Chair. So, Mr. Clerk, you are here to discuss exclusions under cabinet confidences, according to the motion. How many such exclusions or redactions of so-called cabinet secrets were a part of the package that were released?
Chair, I regret, but I think we're back to the initial round. I am not in a position today to get into the numbers of documents. That's right.
And you can't tell us whether all of the documents excluded or redacted actually appeared at a cabinet meeting. Now it seems that you're saying that you didn't even see all the documents, even though we're told that you were going to be coming here to explain why they were redacted or excluded. So effectively, we're not getting any new information or rationale today that we didn't already have. Which brings back memories. The Ethics Commissioner reported that 9 witnesses could not provide information in the SNC-Lavalin investigation because, again, of cabinet confidences as so defined by your office and by the Prime Minister. In it, he says, I was therefore prevented from looking over the entire body of evidence to determine its relevance to my examination. Requested democratically by Parliament. And furthermore said that he was unable to fully discharge his investigatory mandate, again, because of the application of so-called cabinet confidentiality. Has the Ethics Commissioner been in contact with anyone in the government to acquire information regarding the WE scandal, to your knowledge?
No.
So he has not asked for any documents or any witnesses in the government, to your knowledge?
That is correct.
So you have not been summoned to testify in his investigation or answer any of his questions?
No, I have not.
And would you, if he were to ask for to see the documents that you have redacted or excluded under the pretext of cabinet secrecy, would you take the same approach in this WE scandal investigation that you took in the SNC-Lavalin investigation?
As the custodian of cabinet confidences, I would take the same principled approach to every case. And Chair, given that the member has opened the door to the SNC-Lavalin case, I think it is worth pointing out that I indicated to the Ethics Commissioner that had he grounds for believing that specific cabinet confidences might assist him in his work, I was more than prepared to receive such overtures, and I did not receive any. I applied the doctrine of cabinet confidence in that case, the Prime Minister having already waived substantial cabinet confidence.
But sorry,
that
Mr. Sugar, but with respect his report, which is a matter of public record that you have not publicly disputed until now.
Mr. Polyev, I have the if I looked at the time, the clerk, in the combination of your last two times, needs a few more seconds to complete his answer. I'm not going to.
I hope it won't come off my time.
Mr. Clerk, finish your statement, please.
Well, just to say, Chair, that the Ethics Commissioner and I did have an exchange of letters. I was entirely prepared to hear from him with respect to his reasons and the grounds for requesting further information, and there was no further request, and the matter stayed there. And I do not dispute his report, except to say that the Ethics Commissioner is likewise a servant of the House of Commons, and I deeply respect that role.
Yeah,
but I am a servant of the executive.
We'll have to go back to Mr. Polyev. Go ahead.
But with respect, the Ethics Commissioner has indicated that there were 9 witnesses prevented from providing information to his investigation into the SNC-Lavalin scandal.
Mr. Chair, point of order. Point of order.
So.
We are starting to get into SNC-Lavalin.
A point of order.
We are starting to get into SNC-Lavalin, a completely different case. I don't find the relevance to what it is we're discussing and I don't see the relevance to this motion now.
Thank you, Ms. Sirwitz. We'll try and keep it relevant to the motion that we asked the clerk here for. Mr. Polyev, you have time for one last quick question.
So the Ethics Commissioner did provide a rationale of what he needed and why he needed it in the context of that cabinet confidentiality dispute, which we are now discussing another today. And still, the government prevented him from receiving it. So, Mr. Clerk, allow us to be suspicious about the government's, in particular the Prime Minister's, good faith when it comes to the application of so-called cabinet secrets. If the so-called cabinet secrets was used as a pretext to prevent the truth from coming out in the last scandal, why should we not believe it would happen in this scandal?
Point of order, Mr. Chair. I'm sorry. This is completely irrelevant to what we're supposed to do.
The question has been asked. We'll let it go. Mr. Clerk.
Well, I would never presume to limit the suspicion of members of the opposition or any members of the House. But I would say that as a servant of the executive branch, I applied the principles of cabinet confidence in terms of whether disclosure outweighed the public interest. And in that particular case, as in every other case on which I have to make a judgment, that was the outcome. And I think the ethics commissioner understands that, even though undoubtedly he doesn't agree. But that dynamic tension between the legislature and the executive branch is part of our system.
Okay, thank you. Thank you both. Mr. Fraser and Mr. Fragiskatis are splitting their time. Mr. Fraser, the first 2.5 minutes roughly.
Thank you, and please cut me off so I don't intrude on my colleagues' time allocation. Ms. Shugart, thank you for being here. I appreciate your willingness to come testify before the committee. During your opening remarks, I believe you described your approach as a principled approach that would ensure a non-selective redaction of the documents. I take that to mean that there were certain rules in place that you would have employed to ensure that no one could game the system and for partisan reasons have certain documents redacted. Could you explain in your own words what you meant by a non-selective approach?
Gladly, Chair. One can imagine that if there were not any application of principles at the outset of the exercise, that even neutral public servants might be inclined to look at one document and say, oh, this will be awkward, and we won't release it, but this one will be all right, so we'll release it. That is not the application of the principle of cabinet confidentiality, and it can't be allowed to stand. Therefore, I gave direction, as every other clerk before me has, to apply the redactions, if there were to be any, on a consistent basis, so that if there was anything that the Prime Minister or ministers had already spoken to, they were to be released. If they went to the core of the issue about timing, about the advice that had been given in this particular case, our bias was to release them. Now, there might be other principles, such as national security. I don't think that would have applied in the We Charity case, but it would in others, that a public servant might say, we need to think about this one, and we need advice on this particular issue, and that question would be examined from that point of view. But that's what I mean by a principled approach at the outset.
Quick, snappy question, Mr. Fraser.
Sure. You also gave testimony, Mr. Shugart, today that there was no consultation with the Prime Minister nor any cabinet ministers who would be the custodians of these documents during the process. Given that there wasn't that nature of ministerial intervention and the non-selective approach, do you have confidence that any of the redactions were in fact made independently without any partisan considerations, as the normal course should be?
I am completely confident that public servants consistently did their job and applied, according to the principles that had been set out, all of the examination of the records. I'm very satisfied.
And free from partisan considerations.
Absolutely.
Thank you.
Mr. Fragiskatis.
Thank you very much, Mr. Chair. Mr. Shugart, I want to quote something. It's from the National Post, so my conservative colleagues can avoid saying that I'm biased here in citing the quotation. It's attributed to you. I just want to read it to you, and you can confirm whether or not you said it. It's from a 2019 piece around the time you were appointed clerk of the Privy Council. It says as follows: speaking to our parliamentary committee last June, Mr. Shugart also provided some perspective on his role as a public servant. And then here's the quotation. Under both Harper and Trudeau governments, I have personally had the experience many times of giving ministers unwelcome advice and welcome advice. Good news and bad news, he said. That is our responsibility, end quote. Mr. Shugart, I asked this question because of what's been accused on the part of Mr. Poilievre. First of all, did you say that. Is that quote accurate?
That quote is indeed accurate. It sounds very much like something I would say and did say.
So you serve cabinet, you serve the Prime Minister, but first and foremost, is it fair to say that the Clerk of the Privy Council serves Canadians?
Yes, but I have to be clear. I'm a bit of a stickler about these things. The public service serves Canadians in some of our functions very directly. The agent at a call center serves Canadians very directly. The agent at a Canada Revenue call center or service center does it directly. But we serve Canadians through serving the executive branch of the government. We are part of the executive branch. We serve the government of the day, regardless of stripe.
Understood. But you are not under the thumb of the Prime Minister. That's what's been implied subtly by Mr. Poilievre and Conservative opposition colleagues at this committee in previous meetings, unfortunately. Have you ever had pressure on you to offer partial advice? Excuse me.
That'll be the last question, Mr. Fragascadis. Mr. Clerk.
My advice is to the very best of my ability, and I don't want to personalize it. This is true of all public servants, is impartial in the sense that it's not appropriate to have an interest in the partisan benefit or interests of the government of the day or any other party. We give our advice. We also take direction as to the decisions of the government of the day. But we do our best to give professional, truthful advice. Is there human bias in that? Of course there is. But it is professional and nonpartisan.
Okay, thank you. And we only have about 5 minutes left. So, Mr. Fortin, we're into 2.5 minute rounds in any event. Mr. Fortin and then Mr. Julian.
Thank you, Mr. Chairman. Mr. Shugart, I understand that you said earlier that there, let's say, were some 20 officials who were in charge of this project, and you were ultimately responsible. So what I'd like to know is if you personally saw each page of text before anything was blacked out. If someone took out, say, lines 3 to 10, did you see what had been proposed to be blacked out?
Did not. This was delegated responsibility to other public servants. And si je peux souligner.
And if I could emphasize, I'm sorry, I only have 2 minutes. Thank you, Mr. Shugart. We could have a very long and I'm sure most interesting discussion, but I'd ask you to give me the names of the people who oversaw this operation. The other thing I'd like to ask you is, was there any information in these documents that concerned We Charity Foundation, or was it all information concerning We Charity? If you understand the distinction, that's two different corporations, two different businesses. So was We Charity Foundation involved in any of the passages that were blacked out of these documents?
When you're answering, Rial, could you adjust your mic a little bit? It's not coming through clear either. Your mic, the translators were having a little bit of a problem, Rial.
I don't know why. It's plugged over here, and I'm not new.
Mr.
Mike
Clerk.
is just there. What do you want me to do?
Up or down?
If I recall correctly, Mr. Chairman, the documents were only on the We Charity, subject to We Charity, if I memory serves me well. In terms of the names of the officials, I would tell you who the deputy ministers are responsible. Well, what I want to know is who decided to black out these passages. I need those names. So it's up to you to see how you can provide me with that, but that is my request. The individuals who decided to black out some or many passages. No, I will give you the names of the people who are responsible, which is to say the deputy ministers. It is all under their authority. Our practice is not to give the names of individual officials, particularly more junior employees. Well, I understand that, but what I understand from your testimony is that
2.5 minutes. The clerk will finish his answer. We're at 2.5. That was the arrangements we made in the beginning, and that's what we're sticking with. Finish your answer, Mr. Clerk.
No,
ma
that was
question,
all.
je vais finir la question.
But I want to finish the question, Mr. Chairman. You interrupted me to.
Fortin, you're well over time. I'm not going to argue with you, Mr. Clerk. If you'd sum up your answer, or Mr. Julian will not have any time at all.
No, I'd rather hear from Mr. Julian than from me.
Okay, Peter, you're on. 2.5 minutes.
Well, thank you very much. I think. Thank you, Mr. Chairman. Thank you, Mr. Shugart, for being here today. What you're indicating to us, though, is disturbing. That the executive branch basically can go and turn its back on very clear committee direction. And I have 3 questions coming out of that. First, can you provide us with information detailed about the classification for each of the redactions that were done in the month of August, including the issue of documents that, according to some people's criteria, were not relevant? If you could provide us with that information, I think that would be very helpful. Secondly, are you not saying then, I don't want to put words in your mouth, but that the executive does have the right to do the same redaction for documents then that go to the law clerk this time around? If the executive can expand its exclusion far beyond the committee's mandate, is that not a concern? And thirdly, could you explain the uneven distribution of redaction around cabinet confidences by the fact that different public servants may have applied different criteria when they were excluding some of the documents on the basis of cabinet confidence?
Chair, as to the first, I'm happy to provide further information. I propose that be in written form, but that was the offer to the committee, and I'm happy to follow up with further information on that. With respect to the third question, no, I don't believe that there was differentiation between different departments and public servants with respect to the principles applied to the redactions. There was and that's why we set out the direction at the outset to departments, and we've done the same with respect to the current request for documents for the Health Committee. We've provided direction on what should be included in order to do our very best to meet this monumental task that the House has given us. With respect to the second question, yes, I'm afraid that it is a fact that if the executive branch were to give all of the documents of cabinet confidence or commercial sensitivity or solicitor-client privilege or national security to the law clerk, that it would be in a sense waiving that privilege, because the law clerk is a servant of the legislature, not of the executive. And that is not a reflection at all on the law clerk, who is a professional, experienced, highly qualified individual. It's a function of his being a servant of the legislature, and the executive has a responsibility to preserve its ability to do its job as the executive. And frequently that requires not divulging cabinet confidences or solicitor-client privilege or other kinds of information. Now, we want to be as cooperative in this matter with the law clerk as we can. meetings have been held. But at the end of the day, this does come down to our system of governance and this dynamic tension between the executive and the legislative branches of government.
Okay, we will have to end it there. I thank you, Mr. Shugart, for spending this time with us. I believe there is a 2 or 3 areas where you've agreed to provide further information to the committee, and we'll figure that out, I guess, when we see the blues. So with that, thank you again, and we will suspend for a couple of minutes and bring up Mr. Dion. Meeting suspended. Welcome, Mr. Dion. So we have for this session for the next hour from the Office of the Conflict of Interest and Ethics Commissioner, Muriel Dawn, Conflict of Interest and Ethics Commissioner. The I believe you have an opening statement, and we will then start into a round of questions, I believe, with Ms. Jansen first. Mr. Dion.
Merci beaucoup, Monsieur.
Thank you very much, Mr. Chairman. I would like first to thank the Standing Committee on Finance for inviting me here today to speak to a matter that has already generated a great deal of attention at many parliamentary committees. I have obviously followed the committee's work with interest. You have, in fact, asked me to speak about documents that I had already received within the framework of examinations related to the We Charity matter, and you probably wish to know if they contain redactions, admissions, or exclusions. In particular, if you have asked me to discuss cabinet confidence exclusions. As we have already received a large portion of the documents, I believe that I might be able to help.
To members of the committee how the examination process works in order for the office to obtain documents. Examinations may be initiated by the commissioner himself or through a member of parliament or a senator. There are two ongoing examinations, and that's in the public domain, requested by several members of parliament that have brought me before you today involving the conduct of the Prime Minister and the former Minister of Finance. So the first step that we go through in any examination, they're called examinations under the Conflict of Interest Act, is to seek documents in writing. We ask in writing. We seek documents from organizations and individuals and ask that they be shared with us. As we always do, we ask to be provided with documents without edits or redactions. It's expressly mentioned in the letter that we sent each individual or organization. We do not want information to be redacted, and that's made clear in those letters. In our view, to ensure a proper examination that is fair and impartial, we need to be the arbitrator of what is and what is not relevant to an examination. So since my arrival almost 3 years ago, there has only been one instance in the context of which I did not receive the information I requested, and I explained that situation in the Trudeau 2 report, which was just discussed with the clerk of the Privy Council. Second point I'd like to make is that, however, there are strict confidentiality provisions under subsection 48.5 of the Conflict of Interest Act that severely limit my ability to share information collected in the course of an examination. So we ask, we get, we examine, but I am working under some constraints under subsection 48.5 of the Act, which says that unless otherwise required by law, the commissioner and every person who works with me may not disclose any information that comes to their knowledge in the performance of their duties and functions under this section, unless the disclosure is essential for the purposes of carrying out my powers to examine, or in order to establish the grounds for any conclusion contained in a report. So that's all, and there's another exception which is not applicable to the situation we're discussing today. So on cabinet confidences, so we seek all information. We say, please do not send us redacted, excluded, exempted material. Do not exempt material, do not exclude material. So on cabinet confidences, and my position is based upon my reading of the relevant parts of the Act, my view is that we have a right to have access to all needed information for an examination, including cabinet confidences. In Part 4 of the Act, under Mandate and Powers of the Commissioner, subsection 44.9, reads as follows. The Commissioner may not include in the report any information that he or she is required to keep confidential. So the protection is there for cabinet confidences. Former Commissioner Mary Dawson addressed the Standing Committee on Access to Information and Privacy and Ethics on the topic of cabinet confidences, as did I in the Trudeau 2 report. And in her submission back in 2013, she, regarding the 5-year review of the Conflict of Interest Act, she said that it must be clearly understood that the Commissioner has the authority to access any document needed to conduct his or her investigations. Moreover, these documents must be provided directly to the Commissioner and not vetted by any other party so as not to compromise the integrity of the investigative process. So we talked about Trudeau 2. I've made the observations, and to avoid potential delays in examinations and to carry out my proper investigative mandate, I must have access to all information. I consider necessary to carry it out. So I've mentioned some sections. There are some further other obligations under Section 51 of the Conflict of Interest Act that pertain to recusals when a matter is under cabinet confidence, Section 90 of the Parliament of Canada Act. So they're a vital component. I must see those cabinet confidences, and they are properly protected by the office, both in preparing the report and in making the report public. As an independent officer of Parliament, I must have unfettered access to them. Depuis que votre comité a...
Since your committee began its study last summer, there have been dozens of hours of witness testimony. If I could only use this testimony, I would be able to finalize my reports more quickly and avoid wasting the time of many witnesses involved in the matter. From a legal point of view, I am not able to refer to it at the moment, as it is protected by parliamentary privilege. The Speaker of the House of Commons has informed me 10 days ago that he did not have the sole authority to grant my request because I asked if I could use this testimony that was heard by the standing committee. But he suggested that I directly request this of the committee, which I'm doing today. Therefore, for the purposes of the office's ongoing examinations, I respectfully ask, Mr. Chair, that you recommend that the House waive the privilege associated with witness testimony before the Standing Committee on Finance in the context of a study on We Charity and the Canada Student Service Grant. Mr. Chair, those are my remarks. I would simply like to remind members of the committee that there are considerable limits to how open I can be in answering your questions here today, as I must be mindful of the strict confidentiality obligations set out in the Conflict of Interest Act. Thank you very much.
Thank you very much, Mr. Dion, and we'll start into the 6-minute round with Ms. Jansen, who will be followed by Ms. Kotrakis. Ms. Jansen, floor is yours.
Yes, thank you. I wanted to ask Mr. Dion, first of all, thank you very much for coming. And I just wanted to ask him about the letter that he sent in regards to the inquiry we had talked about on Mr. Morneau. And I'm really confused with your ruling of not beginning an inquiry into Mr. Morneau's unpaid travel with his family, funded by We Charity. It's my understanding that since 2017, the
Mr. Chair, point of order. What does this have to do with discussing cabinet confidence exclusions to public disclosures? Point of order.
I think I will allow this one because it does relate to the We Charity. So I will allow this one. Go ahead, Ms. Jansen.
Additional point of order, Mr. Chair.
Yeah.
I just am having a really hard time hearing. I think the audio is coming through both the room you're in as well from Ms. Jansen. I just am having trouble hearing.
Okay.
Yeah. It sounds like it's better now. Yeah, can I continue?
Yes, you can continue, Ms. Jansen.
Okay, so it's my understanding that since 2017, the year of his trip, We Charity has received over $5.3 million in federal grants and contracts. So in Section 15 of the Ethics Code, it states that trips over $200 must be disclosed within 60 days. And we all know that he didn't do that. And yet you say in your ruling he didn't travel in his
Jansen, I'm not going to allow you to go too far by talking about all those things. Try and relate it to the purpose we invited Mr. Dion here for. Not to make another case.
Well, I guess it's really hard to ignore the fact that the We Charity government's funding increased exponentially after his trip. So on what basis do you decide that he's not wearing his MP hat? Like, how do you make those decisions?
So as I mentioned, there is an investigation, there is an examination currently underway in relation to the former Minister of Finance. And I will, in the report that will be made public at the appropriate time, discuss the reasons why I decided not to pursue the aspect of the trips and the reimbursement for the trips. I will explain that in the public report. I have no authority to do so until then.
Okay, so reading through your ruling, of course, I'm new, so I want to make sure I understand well. You mentioned that in your decision that since Mr. Morneau's wife made all the travel arrangements, that was proof he didn't go officially.
Point of order, Mr. Chair. I don't know.
I'm not going to. I'm going to give some leeway here so that we can get a final answer from Mr. Dion. Go ahead, Ms. Jansen.
Okay, so what I'm understanding from that then is that if my husband Byron organized a trip to, say, Kenya for the two of us to visit a charity, and later that same charity gets 5 times the government funding than they had prior to my visit, as long as I wasn't involved in any of the coordination of the trip, there'd be nothing ethically wrong with that. But from where I sit, that perception would be that I hooked them up. I wonder if you could kind of help me with that.
I will, as soon as I publish a report that will explain fully the reasoning behind the decision not to pursue that further.
Okay, so the ethics code says that a member of a family or a member can accept a gift which could reasonably seen to compromise them in their office. And now I realize Mr. Morneau's family could quite easily afford that trip. But judging by the increase in funding the We Charity got after their visit, isn't it fairly reasonable to assume that something changed? Like, it really appears that someone put a bug in someone's ear.
Frank, Mr. Chair, I don't know what to answer to that suggestion.
Well, if you can't answer, you can't, Mr. Dion, and I would ask Ms. Jansen not to continue to go down that road on a family that is, the individual is not a member of Parliament right now. I think I'm getting calls for a point of order from the room here. I've allowed a lot of leeway on this, so I would try and hold it to the cabinet confidentiality request that we made in our submission to invite Mr. Dion and the clerk here.
Well, I guess I'm trying to wrap my mind around, how the ethics commissioner makes his decisions, and we received this letter. So I'm trying to, like I say, truly understand, how does someone like himself make a decision? So we know, for instance, that Mr. Morneau did not recuse himself from cabinet discussions about CSSG, and he said so himself. And yet you're not allowed to see those cabinet documents. How can you actually do your job that way? I'm just really trying to wrap my mind around it.
No, in fact, I think I was suggesting in my opening remarks, and I'm pleased to have an opportunity to clarify that we did receive all the documents we need in order to conduct these 2 examinations, including cabinet confidences.
Okay, so again, just trying to wrap my mind around how exactly you go about making your decisions. For instance, you mentioned in your other ruling, Mr. Morneau had no involvement in the decision to fund the We Charity Student Entrepreneurship Initiative because he told you he didn't. So how exactly do you determine he had no involvement, or do you just simply take his word for it? Is that how that works?
No, in fact, the team that conducts the examinations, as well as the legal team, they sound like they're big teams. We're talking about 4 people altogether. Reviewed the sum total of the documents that I was talking about, as well as the submission made by Mr. Morneau, and they recommended to me, and I accepted the recommendation, that on the balance of probabilities, we were satisfied that with Mr. Morneau's assertion. So that's how it happened. That's how it works in any examination. It's on a balance of probabilities. We have to decide whether we accept the version offered by the person who's the subject of the examination, or we accept other assertions elsewhere. And so it's the totality of the evidence that leads us to a conclusion as to whether the act or the code have been contravened.
Okay, thank you both. Ms. Kotrakis, 6 minutes.
Thank you, Mr. Chair, and thank you, Mr. Dion, for being here before us today. I hope you and your family are keeping well. I know that you're working really hard with your team, and we're very grateful for the work that you and your team do. Can you speak a little bit more broadly about the ethical behavior of our nonpartisan public service? What policies or mechanisms are in place to ensure that our public servants will act in an ethical and an unbiased manner?
I believe you're muted, Mr. Dion. We can't hear you.
Good. So we're back. I'm happy to receive this question in order to clarify something that's not clear to everybody involved, that the Conflict of Interest Act only applies to the most senior levels of government. So we're not talking about the public servants at large. We're talking about governor and council appointees, ministers, exempt staff, period. We're not talking about directors general, and up to and including assistant deputy ministers. They're governed by something different, the code developed under another authority. So I'm not responsible for offering educational activities, for instance, aimed at public servants. It's the responsibility of the Treasury Board and that of each department, line department. My role is to focus on, again, the people I've mentioned, the Prime Minister, the ministers, the secretaries of state, the governor and council appointees, and such senior people, and as well as exempt staff. So we have 3,000 people, not the 400,000 people who are governed by the other authority.
Thank you for that. Pensez-vous qu'il y a eu...
Do you think that there was any political interference in the redacting of the documents for the Canada Student Service Grant? Well, as I said, we received all of the documents in their integral form, and I didn't analyze what the committee saw, but from my end, there was no redaction. And what are the policies that are put into effect to avoid any political interference in the redaction? Well, I think Mr. Shugart tried to answer that question earlier. That really doesn't come under my mandate. I take it for granted that I'm sent unredacted documents. So I've had to ask a court in the past, but when you send a letter to a person or an organization, I think they take it seriously. And I said there was only one situation in 3 years where there was an attempt to redact any documents. So it's not an issue for me. And if you come to a conclusion, when a committee comes to a different conclusion on the same issue, would you find it useful? Do you think that this could undermine confidence in the process? No, I think that we have processes that are quite different, and we also have the non-partisan aspect that's true of our office. When a parliamentary committee can, of course, be partisan and often is, but those are two completely different frameworks. My work, if I may, Mr. Chairman, say in 30 seconds, my work is to carry out an examination when a parliamentarian has asked me to do so, or if I decide to do so on my own. And my job is to provide my conclusions, to look at the facts, analyze them, and to draw a certain conclusion, and to share that with the Prime Minister under the Act. That's the way the Conflict of Interest Act works. So I can make it public an hour later. I can publish the report, and I say to the Prime Minister, in my opinion, there was a breach or there wasn't. And that's the way it works. So it's not at all the same prism through which the committee sees these things. Thank you.
Then you do have time for one more. If you okay?
Yeah, I have one more.
Yeah.
A recent independent audit of the administration of the CSSG to We Charity conducted by Mr. Matt Torigian, who is the former Deputy Solicitor General for the province of Ontario, has shown that the government and Prime Minister's office did not predetermine that We Charity would be selected to administer the program. To what extent have you taken these findings into account, if you have, when investigating the administration of the CSSG? And yeah, I'd like to hear your thoughts on that.
Again, you're muted, Mario. You're muted yet.
Okay, here we are. So my team has received thousands and thousands of pages of documents. I do not know for a fact whether this report is part of it, but I can assure you that after you've mentioned it, we will of course obtain a copy and we will review it to determine whether it contains any useful information to us. Because in addition to what we seek and receive, we also, of course, on our own volition, we do web searches. We obtain publicly available documents that pertain to our examination. So you've just mentioned one about which I was not aware, but it doesn't mean my team wasn't. Thank you.
Thank you. We'll go to Mr. Fortin, followed by Mr. Julian. Mr. Fortin.
Merci, Monsieur.
Thank you, Mr. Chairman, and thank you, Mr. Dion, for being with us here today. Mr. Dion, I understand that you saw the 5,000 pages of documents. We say 5,000, but all of the documents related to the July 7th motion. Is that true? Well, my office received them, and the investigator reviewed them, yes. I haven't seen them all. No, not yet. How many people in your office or within your service saw those documents, rather? I imagine it's a team. One person reads page 1 to 100 or something like that. Well, I think that the investigator in this case read all of the pages, and he's supported by a lawyer who also read all of the documents. So 2 people. Is it as well as their supervisor, of course. That's one person. So there's the main lawyer who's responsible for these studies and legal services and oversees all of those activities. And in this case, it was Marie-Josée Smith, who was the investigator, and Michael Aquilino, who is the legal counsel on both the Trudeau and Morneau cases. All right, so those people saw all of those pages and saw what was being proposed to be blacked out, if I understand correctly. No, I'm sorry, Mr. Chairman, but that's not. We're not comparing at all with what the Finance Committee received. We didn't try to do that. We asked for tens of thousands of pages of documents on our side. So for the blacked out documents, you can't speak to us about that at all? No, well, as I said earlier, the interpreter regrets they were both speaking at the same time.
And then back to Mr. Fortin.
Okay. Monsieur.
Mr. Dion, sorry. Yes, I had finished, Mr. Dion says. Okay, Mr. Dion. In the documents that you looked at, do you recall having seen information concerning the due diligence report or document, as we refer to it? Well, I myself did not look at all of the documentation, and I don't know if that was there. We're not at that stage. Well, could you let us know if there is or not, within the documents that we received, a due diligence report? Well, as I was saying in my preliminary remarks, I'm not able to tell you what's been revealed to me within the context of an examination until I've written my report. If it's relevant, the report will refer to it, and we can speak about it at that point. Okay, that pretty much limits the questions we can ask you. If not, we're talking about the theory of what's ethical or not. But, well, that's it. So can you answer me? You can't answer me any questions about the documents, if I understand correctly, in terms of the content? Well, no, other than very general questions, as I said earlier, and as I said to the previous member, I'm not aware if there was some such a document about a report. So I can't talk about the relative importance of documents until the process is complete. Well, perhaps we'll meet with you again at that point. And now, having said, I'll concentrate on theory then, Mr. Dion. I'd like you to tell me a bit about the responsibility of the people who redact these documents. I understand that there are processes that must protect cabinet confidences. That's fine. But earlier I saw with Mr. Shugart that there are a certain number of people, perhaps between 12 and 25 people, and as well as a few supervisors, I don't know how many, who see all of these documents. And Mr. Shugart is responsible at the end of the day for the redaction. So I would like to know, from an ethical perspective, given the responsibilities for disclosure that flow from this motion, talking about all these redactions, at what level, and how can I put this, of reliability is there to this? How can we check on if what is blacked out has been properly done so? If there was a mistake, for example, in the redaction, if some staffer decided to black something out when they shouldn't have, how can we at the committee ensure that this was done correctly? I have no idea. That doesn't come under my mandate, but if the exemptions and exclusions if they were applied correctly, you'd have to turn to a court, but courts don't have any, can't do anything in terms of parliamentary privilege. Well, I think that government institutions have to respect the wishes of the committee. Is that not correct? Well, I'm still an official, and I've been working for 40 years. And I always believed that we had to respect Parliament and respect their requests. Yes, but in principle, don't the officials have to send us all of the documents that we requested? Well, I think the law clerk could enlighten you on that. I think the committee has certain powers. I have the impression that we bothered you for nothing, Mr. Dion, but I thank you very much for having been willing to come.
Mr. Julian. Mr. Julian, we're in a 6-minute round.
Thank you very much, Mr. Chair. Thank you, Mr. Dion, for your presence here today. And we certainly hope you and your family and loved ones are staying safe and healthy during this pandemic. You're getting sort of a bunch of questions, in part because this committee was shut down in August. So we had important testimony at the end of July, early August, of ethical considerations. And then the entire Parliament was shut down mid-August, as you know, with prorogation. And subsequent to that, the Finance Committee has been held up for the last 2 months because Liberal members didn't want these documents discussed. So it's been 4 months since the Finance Committee has actually been able to question a witness on these important things. So I guess I apologize on behalf of the entire committee because of all of this shutdown and basically the committee being suppressed. We now have a bunch of questions to ask. My questions relate to the Prime Minister's testimony before us on July 30th. And Mr. Shugart's testimony before us on July 21st. Mr. Shugart testified just before prorogation that there were 2 cabinet discussions around the issue of the We Charity and the substantial funding that the federal government wanted to put. He also testified that the Prime Minister had concerns, and the Prime Minister testified about this as well, around possible conflicts of interest. So I wanted to ask you first if the Prime Minister or the Prime Minister's office contacted you, the Ethics Commissioner's office, around a potential conflict of interest, whether you would expect that they normally would, if there were potential conflicts of interest, that they would actually reach out to you. And have you received the cabinet documents that reference the 2 discussions that cabinet had around this program?
So, Mr. Chairperson, I'm afraid I will once again disappoint members of the committee by saying that whether a public office holder, whether it's the Prime Minister or a much more junior one, consults us or doesn't consult us is something that is private between the person in question and my office. There are clear provisions in the Act that any advice we give to a public office holder is confidential, and I'm not at liberty to discuss it. The obligation to recuse oneself belongs to the public office holder. Section 21 of the Act makes that very clear. We recommend that people, when in doubt, should consult with us. In fact, I gave an information session recently to 250 people in which I made clear the point that one should consult because we are more specialized, and number 2, we are more objective as well when it comes to telling or recommending a course of action. But the person is, at the end of the day, the person is accountable for his or her decisions to recuse or not to recuse. So I hope this answers your question. We did seek all relevant documents, including cabinet documents, and we've received them.
And you're unable to confirm that there were two cabinet discussions around this issue. Mr. Shugart did testify to that effect.
Not at this stage, no.
Okay, thank you. Now, this is public domain, so we're not revealing any confidences. The former finance minister had admitted just this summer, again, before the entire committees, all committees were shut down by the prime minister, that he had not read the conflict of interest rules. Do you suggest that all cabinet ministers, and in fact, all members of parliament, should pay strict attention to conflict of interest rules and should actually be reading conflict of interest rules and regulations so that they understand their responsibilities?
There is no doubt in my mind that anybody appointed to a senior public office should take the time to review the short Conflict of Interest Act. We're talking about 60-some sections. We're not talking about reading the Income Tax Act or the Criminal Code of Canada. It's entirely feasible. It's not plain language, but it's actually understandable. And we also have on our website, we have interpretation bulletins on several of the obligations under the Act. So by all means, there is no question in my mind. In fact, my advice has been, before being the ethics commissioner, that because I've been a senior public office holder for something like 25 years before that, read it once a year. Not only read it upon becoming a public office holder, but once a year, gives you some assurance that you actually remember the various obligations that you have under these instruments.
Yes, and that's good advice to all members of cabinet, I think, moving forward. Now, we had testimony before this committee on July 28th, and it was from the Kilberger brothers. And they clarified that payments for auxiliary events where donors and potential donors get to sit and meet with some of the talent was part of the We Day charities. Now, I'm interested in knowing whether that information, this isn't a public office holder communicating with you, but were you aware of the involvement, the WE's approach and these auxiliary event payments? Is that something that your office would be aware of that might involve public office holders or their families?
We are aware, and we are now aware, and it will, of course, be reviewed in our report.
But you weren't aware previously, so that was new information.
Again, what is brought to our attention and not brought to our attention, I'm afraid, is a matter of confidence between ourselves and the Prime Minister, the Minister, or anybody else with whom the office deals.
Last question, Mr. Julian.
My final question is, what advice do you have for the Prime Minister and the government regarding these issues around conflict of interest, which have happened in repetition? You've certainly been able numerous times to judge the issue around conflict of interest. What would be your suggestion moving forward for the government to avoid these problems occurring yet again?
We've already discussed the fact that one should read periodically the Conflict of Interest Act. I have, as it's not a well-known fact, but under Section 23 of the Act, I have the authority to provide the Prime Minister with confidential advice as to what should be done, either in a specific case or in general. So there is a tool whereby I can make my views known to the Prime Minister, but again, it's confidential.
Okay, thank you both, and we'll go on to Mr. Polyev, who will be followed by Mr. Baker. 2 5-minute rounds, unless someone wants to split their time. Mr. Polyev.
To clarify with you, Mr. Commissioner, I understood your earlier testimony to be that the government has handed you over the same 5,000 pages of documents that it handed over to the committee. Was that your testimony?
No, my testimony was that we didn't try to compare what we received with what the committee had received. So I'm in no position to compare, but we seem to have received slightly more pages.
More pages?
Yeah.
I would like to ask on behalf of committee that you perform that comparison and report back to us so that we might ascertain whether or not we have received all the documents we should receive. Would you commit to doing that?
Maybe we didn't ask for the same documents. Maybe we asked for a much wider set of documents that could explain the discrepancy.
would you be willing to report back to us on the documents on a comparison between what we received and what you received?
So what I'll do is I'll discuss with my staff and determine the workload associated with doing that, because I would not want this to detract from finalizing reports as soon as possible.
And have you're saying that you had no redactions or exclusions in the package that you received?
That's what I said. That's right.
That is very strange.
Except for material that did not pertain. So sometimes you have a document in which you talk about 90% is about the subject at hand.
I understand.
That's right. But apart from that, no. That's what I've been told by my team.
Okay, that is very interesting. Have you ever encountered a situation where the government has applied the cabinet confidence as a rationale for excluding evidence that has prevented you from properly executing your investigatory function?
I've already mentioned, Mr. Chair, the Trudeau, what we call the Trudeau 2 report, the SNC-Lavalin report. It's called by some the SNC-Lavalin report. That was the only instance where we did not, we sought and did not obtain, decided not to insist, but we did not obtain the full gamut of documents that we were seeking from the government.
And did that prevent you from doing your full discharge of investigatory duties?
It did not prevent me from reaching the conclusion we reached in the report. That's why I decided to proceed in the absence of the additional documents.
It does say in your report that because of my inability to access all cabinet confidences related to the matter, I must, however, report that I was unable to fully discharge the investigatory duties conferred upon me by the Act. Is that accurate?
Yeah, it reflects the well-known maxim that you don't know what you don't know.
Right.
But I decided pragmatically that we had to come to a conclusion, so I did back in last year.
Yeah, so even without all the information the government deprived you of, you were able to conclude that the Prime Minister had violated the law. And so you just went ahead with your conclusion. I understand that, but it is clear that the government's unwillingness to provide you with all of this evidence, in your words, rendered you unable to fully discharge the investigatory duties conferred upon you by the Act.
That's what I wrote in the report, and I stand by that, of course.
Right.
But I did make the decision not to go back to the clerk, as you mentioned earlier. So.
Yeah, I understand, but still it is clear that the government's use of quote-unquote cabinet confidences as an excuse prevented you from doing your duty and completing the full scope of those duties under the Act, the Conflict of Interest Act. Were you able to see any evidence to confirm that the information they were withholding was in fact cabinet confidentiality?
No, because I didn't see the information.
Right. So you have to.
That's the problem, the egg and the chicken problem. You don't know what there is, therefore you cannot really assess anything.
So you can't be sure that the information that the government claims was a cabinet secret was in fact cabinet secrets.
That's right.
And so now the government is telling us once again that they can't give us evidence because it's all cabinet secrets. But we had the clerk of the Privy Council tell us today that he can't confirm that these so-called secrets ever reached the cabinet table. Do you have any way of telling us how we can unravel the mystery of whether these are in fact cabinet secrets they are depriving us of?
No, I'm afraid I don't. I'm afraid I don't have any secret to offer on this one.
So we'll just have to take the Prime Minister's servant, whom the Prime Minister can fire and whom he hires at his
Chair. Point of order.
Mr. Polyev, does the point of order? What's your point of order? Mr. Polyev is out of time, but what's your point of order?
I would advise my colleague that he should read the Magna Carta that is on his bookshelf. If he does, he'll understand the basic principles of democracy.
I think that's stretching the point of order. So we'll go on
that
to.
The clerk is independent, and that he should stop besmirching his reputation.
We'll go on to
Mr.
Mr.
Chair.
No.
Point of order, Mr. Chair.
What's your point of order?
Yeah, you interrupted me before I was done my time, and did not allow me to finish.
Your time you were over. This is a 5-minute round, not a 6.
Yeah, but I wasn't finished 5 minutes.
Yes, you were on both my clock and the clerk's. Mr. Baker and Mr.
Clock.
Fraser are splitting their time. Mr. Baker.
I'm going to yield to Mr. Fraser first.
Okay, Mr. Fraser first, and then Mr. Baker.
Thank you, and thank you to Mr. Dion for joining us as a witness today. During Mr. Shugart's testimony earlier in this meeting, he explained the process that was employed to make certain redactions. And I'll remind committee members that the reason that we've asked each of you to come here is just to discuss redactions on cabinet confidences. He if I can summarize, explained that they established a process and a set of rules that would be employed. The responsible deputy ministers had their staff then execute the redactions according to those rules. In your testimony, you explained that your rules apply to senior officials within government, and Monsieur Fortin, during one of his questions today, raised the issue of what if a civil servant did things the wrong way? What if they made a redaction they shouldn't have, for example? This has been the current that's been underpinning the last number of meetings we've had on this particular issue. The allegation that no one has seemingly made that explicitly, but seems to be hanging over everyone's head, is that some civil servant would have been directed by the government to redact this or that, and that would have been inappropriate given what the committee had asked it to do. If Mr. Shugart's testimony is true, and I believe it to be true, I believe him to be a man of integrity, and more importantly, the person who holds that position must be beyond reproach. If his testimony is true, that there was no consultation with ministers or the Prime Minister, and in fact the deputy ministers charged their civil servants beneath them to execute these redactions in accordance with the rules, do you think that there could be an ethical violation if, in fact, the testimony Mr. Shugart gave today is true?
Yeah, I follow your question. I listened to the clerk. I also believe that it was done in the manner that is described, but it's always possible. In spite of the directions, it's always possible that somebody doesn't follow the directions, but I don't know. I'm just stating a fact.
Certainly, and I'm not asking you to suggest whether someone did break the rules. I'm asking if, in fact, the clerk's testimony is true, that there was no ministerial interventions to direct such redactions to take place. And if a mistake, even if there was a mistake made, would that constitute any kind of a violation of conflict of interest or ethical requirements on those that are subject to the rules?
No, it wouldn't, because the Act deals strictly with the conflict between a private interest and a conflict between that and a public interest. So it wouldn't apply.
I appreciate that. And very quickly, before I hand it over to my colleague, you mentioned that full disclosure had been made with the exception of documents that did not pertain to what had been asked for moments ago, and that satisfied you, that you had the information to do your work. Just on the issue of those particular redactions that do not pertain, I used to run into this when we would deal with disclosure in litigation in my career before politics. There was no real difference in my mind to things that were not relevant that were included in an otherwise relevant document and other documents that just had no reference whatsoever. In your view, does the obligation to disclose change at all because an irrelevant portion is contained in a document that may have some relevant material? Or is it similar to the millions upon millions of documents that are within the custody of the Government of Canada that the government just chose not to produce because they're not relevant?
No, I think my preference, as I stated in my opening remarks, is that we get everything that's covered by what we've asked for, and that's what I believe what we've received. In fact, I would prefer that no redaction be made because we can be the judge of what is irrelevant to what we've asked for. The more information we get, the better it is for us.
Certainly, I'm asking not necessarily what's more or better, but whether it's in accordance with the rules.
The rules is I ask you, you give me. So It's akin to a court of competent jurisdiction. So in doubt, provide it. That would be my advice.
Well, I've not saved much time for my colleague here, so I'll let him take over.
Okay, and your colleague has got about 25 seconds to make his question and get an answer. Mr. Baker, do you have a very, very quick one?
Yes. So is there any indication, Mr. Dion, that anything has been done by anyone in the public service, in the executive branch, or anyone else that has prevented you from fully performing your work in this case effectively?
No, there's nothing of that nature.
Thank you very much.
Thank you all, and you did it right within time. Mr. Fortin, 2.5 minutes, followed by Mr. Julian for 2.5. Mr. Fortin.
Merci, Monsieur le Président.
Thank you, Mr. Chairman. Mr. Dion, I'd like to know, in your opinion, you have a certain security level, or clearance rather, that gives you access to unredacted documents. Am I right to assume that the law clerk has the same level of security as you would have? I'm not aware of what his security clearance would be. I have top secret, and he could compare that with mine. In your opinion, would the law clerk be able to say whether he was able to receive all of the documents without any redaction, with possibly some note from the clerk of the Privy Council saying this is what I suggest would be redacted? Well, I think that there is a distinction to be made here. There is the legislative and the executive branch of government, and I am an officer or an agent of Parliament, but I have the power to get documents, and this time I got them. Yes, but the law clerk, should he not have received the same thing as you received? I have no opinion on that, Mr. Fortin, that I'm prepared to offer. But from an ethical perspective, I would think that is part of your mandate to ensure that the government is accountable, that this corresponds to the applicable standards when Parliament makes a request. So the fact that Parliament is requesting documents that are unredacted to be provided to the law clerk, from an ethical perspective, should the government not have answered and met that request or demand? Well, there's the word ethical in my title, but that's about the only time it really appears, and I don't think it really. I'm just dealing with conflicts between public and private concerns here, so I can't offer an opinion other than on those kinds of conflicts of interest. I'm being very frank with you and honest. Well, you look so competent, and I just wish that you could answer all of the questions that I might have, but clearly that's not the case. So I want to practically apologize, as I said earlier, for having asked you to come here and testify before the committee, because I think you're so limited in what you can really answer to us, Mr. Dion. It's not your fault, I understand that, but I thank you very much. Have a good day.
You're right on time, Rial. Mr. Julian, 2.5 minutes.
Merci beaucoup, Monsieur le Président.
Thank you very much, Mr. Chairman, and thank you, Mr. Dion. You spoke earlier about documents that you had received that were unredacted, and I'd like to know what the process was to obtain those documents, particularly when we are talking about cabinet confidences. Did you send a letter to the clerk of the Privy Council, or what was the process you followed? Well, in fact, every time we start an examination, we determine who may have information, in our opinion, that would be relevant. We make a list of people and organizations to whom we write letters, very clear letters. It's drafted in such a way as so that people can see very clearly what might be relevant to the subject. So in my opening remarks, I said that I can't tell you who we asked what of until the report is published. And then you'll see the list of witnesses and sources. So unfortunately, until that is published, I am unable to reveal to whom we wrote letters. Well, is it possible to share with the committee what was asked? Well, we could perhaps send you the form letter that was sent, as it would show you the parameters of what we were interested in. Yes, because you said in an answer to Mr. Poliev earlier that indeed you may not have asked for quite the same documents. And that might be quite right. The motion was not complied with, clearly, and Mr. Shugart's testimony indicates that the executive was not concerned particularly with following what we asked for to the letter. Having said that, your form letter that was asking for these cabinet confidences would offer us a means of comparing what we asked for compared to what you asked for. So is that possible to have that? Would you share it with us? I'll send it to the clerk. And I'll just ask for some advice as to whether this would be a breach of the act. And if not, I will send it to the clerk so that she can distribute it to the members of the committee. That would be useful. Because if we want to go in depth or to ask more in-depth questions as to what you asked for and what you received, how many pages did you say that you received? All I know is that it's more than 5,000. I don't know exactly.
Mr. Julian, so Mr. Dion, I believe you're going to send that form letter to the clerk.
I will if I have legal advice to the effect that doing so would not violate the Conflict of Interest Act provisions.
We understand that. And in your initial remarks, you said this. Therefore, for the purpose of the office's ongoing examinations, I respectively ask, Mr. Chair, that you recommend that the House waive the privilege associated with witness testimony before the Standing Committee on Finance in the context of its study on We Charity and the Canada Student Service Grant. I'm kind of in the position of I don't know what I don't know that you mentioned earlier. I know how that happens, but I have a question for you myself, and this is what I don't know. It is public testimony. Can you not use that public testimony?
No, the advice that we shared with the speaker is that this is covered by parliamentary privilege, and unless the privilege is waived, we cannot use these testimonials. We cannot use the transcripts of those who testified before your committee, as well as some other committees as well.
Even when it's public, that's news to me. But in any event, if that's what it is, that was is. Here's how we would, just for committee members, and we'll have to think about this. Here's how we would waive the privilege on committee evidence. First, we would have to, as a committee, adopt a report to recommend to the House that it waive its privilege regarding the specific evidence. Two, then we would have the report tabled in the House. And three, then there'd have to be a motion to concur in the report. Somebody would move a motion to concur. And if we concurred in the House, then it would be done and it would be available. So it's a little bit of a complicated process, but that's how we would have to do it. And the committee will have to give that some thought, because I always thought public evidence was public evidence. So certainly learned something new today. Look, with that, we are at time. I want to sincerely thank you, Mr. Dion, for coming forward and providing what answers you could within your responsibilities to Parliament, and to also, on behalf of the committee, thank you for the work that you do as Conflict of Interest Commissioner. Your advice is maybe we don't always seek it often enough, but when we seek it, we're a little wiser as MPs, I can tell you that. So with that, thank you very much, Mr. Dion.
Thank you very much.
And for members of the committee, on Thursday, the governor and deputy governor will appear before the committee on Thursday between 3:30 and 5 p.m. And I think everyone knows that the Bank of Canada tabled its report on monetary policy on October 28th. So that should be good information for them. And hopefully following that, we can have a steering committee meeting. So with that, thank you all. Meeting adjourned.